If he can use whatever means he has at his disposal to convict her, and he succeeds, that would vindicate him and harm the federal investigation of his office. On the other hand, if she's found not guilty, as we expect she will be, he knows that he and his office will remain in the crosshairs of the federal investigation.
Let's begin with the hearing held on February 26, 2024. Just a few days earlier, federal officials turned over a tidal wave of information to the Touhy process, which governs the production of federal documents in legal cases where the United States is not a party. This session is dedicated to scheduling, where they will set key dates leading up to the start of the trial. Enter one Assistant DA Laura McLaughlin. Renowned for her skill in remaining inconspicuous, she had also directly accused the defense team in recent court filings of entirely fabricating a relationship between Michael Proctor and the Albert family, essentially calling Reed's attorneys liars. Words she would soon be forced to eat. The hearing has just started, and a key Commonwealth figure is missing. She signals to an assistant, "Go find Lally." We see the assistant quickly exit the courtroom.
We're on the record on Commonwealth vs. Karen Reed on docket 22 CR 117. Beginning with the prosecution, may the parties introduce themselves?
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
You see, Laura rarely speaks. In fact, she almost never lifts her eyes from her laptop screen. Either she suffers from a gripping fear of public speaking, or she's attempting to minimize her role in the train wreck of a case against Karen Reed. However, on this occasion, we will be treated to some very interesting statements from Laura, but more on that later.
Good afternoon, Ms. McLaughlin.
Miss McLaughlin looks back, hoping to see Lally, to no avail.
Your Honor, Alan Jackson on behalf of this.
Good afternoon, Mr. Jackson. Good afternoon, Your Honor. Elizabeth
As the defense make their introductions, we see Turtle Boy stand up and say something.
Little. Good
Also,
afternoon.
on behalf of Ms. Reed.
Attorney Elizabeth Little notices the disruption.
Good afternoon, Ms. Little.
Aidan and girlfriend Meredith make their way towards the exit. You are witnessing the culmination of a plan by Aidan's detractors to weaponize the legal system against him. He was released from prison a few days prior, and they are determined to send him back, even if that involves setting him up. Their underhanded plan was to invite a woman from Aidan's past who allegedly colluded with corrupt officials to lure him to her apartment, and then make false allegations against him. The prevention order she obtained requires Aidan to leave the premises.
Good afternoon, Your Honor. David Unetti for Karen Reed.
Good afternoon, Mr. Yannetti. Good afternoon, Ms. Reed. Okay.
Allegedly, as Turtle Boy was exiting, Chris Albert commented to him, "Ain't that a bitch?" causing the guards to order him to quiet down. And look who's decided to join us.
Oh, all right. So here comes Mr. Lally. Were you expecting him, Ms. McLaughlin?
Yes, sir.
All right. I'm sorry. I would not have stopped.
Apparently, they were able to locate Adam Lally. He rushes to his chair, being exactly 7 minutes late. He's been known to chain smoke cigarettes outside in the parking lot by his car and looking stressed. Miss McLaughlin is relieved and can relax, just for now.
All right. So, Mr. Lally, if you just say your name for FTR.
Yes, sure. I'm Lally for the Commonwealth. Good
All
afternoon.
right. Good afternoon, Mr. Lally. Okay. So when we were all last in court on February 15th, there was obviously Mr. Lally, why don't you have a seat?
Besides the comical aspects of Adam Lally, in this moment he does seem genuinely out of sorts, blurry-eyed and defeated. And there's a very good explanation for that. Just a few days earlier, the U.S. Attorney's Office had submitted 3,100 pages of evidence exculpating Karen Reed, which we now know to be absolutely devastating to the state's case. The Norfolk DA's office has been in full panic mode, feverishly reading those documents and evaluating the damage. But what exactly is Adam Lally's stake in all of this? He is paid $127,000 annually by the taxpayers of Massachusetts. He's taken an oath as a prosecutor to seek justice within the bounds of the law, not merely to convict. He has virtually zero experience prosecuting high-profile murder cases. Therefore, he must have been assigned to this case by Michael Morrissey for a different reason. It would seem rational to assume he was chosen for his willingness to take morally questionable actions when instructed, and his loyalty. Adding to the mystery is Morrissey's decision not to assign his top prosecutor to the case. Greg Connor, the chief trial counsel for the Norfolk DA's office, is the lead prosecutor on the county's most high-profile cases. He prosecuted Emmanuel Lopes for the murder of Weymouth police officer Michael Reznor and is currently handling the Brian Walsh case. It must have been surprising then, when the far less experienced Adam Lally was assigned to the Reed case instead. Although it would have made sense to assign an underskilled attorney who's willing to bend the rules. After all, Karen was fully expected to fold under the weight of serious murder charges. Also noteworthy is that the Vanity Fair article stated that Morrissey's in-house prosecutors have all refused to retry Reed's case for the second trial. That would include Greg Connor, who is presumably smart enough to not board a sinking ship. Lally undoubtedly saw this as a massive career opportunity. But what explains his willingness to participate in the false prosecution of an innocent woman long after he understood it was getting dangerous? Let's look at the situation from his perspective. Imagine taking part in an illegitimate prosecution. Your boss, the most powerful man in the county, needs this taken care of and says it will be cut and dry. Everything is fine for a while, but then the girl is putting up a fight, causing you to plan illicit actions, slow walk evidence, and lie in court.
I have eyes on the side door.
13 months into the scheme, you learn that the FBI has been watching your office as part of an ongoing investigation for these very crimes.
Lally just exited the building.
You are hearing credible claims that your phone has been wiretapped.
I'm 2 cars behind him.
A wave of terror runs through you as you wonder just how much the feds have uncovered. Weighing your options, one unsettling reality becomes clear. There is no walking away from this. You're already deep into the crime and now can only double down again and again in an attempt to save yourself. Only he knows his exact level of criminal exposure, but judging by everything we've witnessed over the past year, he seems quite concerned for the future. We can only assume that every decision he's made as lead prosecutor has been under intense scrutiny by the FBI. Welcome to the nightmare. If anyone has exposure to corruption charges related to the prosecution of this case, it's Adam C. Lally.
Through 2 years of litigation,
Alan Jackson explains to the judge that more time will be needed to review the FBI evidence and incorporate it into their case.
with the Commonwealth, just about 2 years of litigation, we've received a little over 3,200 pages of data. In one day, the defense was given 3,100 pages of data, and none of it appears to be duplicative. All of it is brand new, and all of it, Your Honor, appears to us to be exculpatory.
We can look back now with the benefit of hindsight and determine that Jackson's characterization of the federal documents was accurate. Throughout the trial, the defense presented shocking new information harvested from those materials, further discrediting the Commonwealth and crippling their already fledgling case. Jackson goes on to discuss the drastic impact those materials will have on their trial preparations. And he is clearly excited to have this powerful new evidence.
But based on what we've gotten so far over the last 48 business hours or so, there's going to be additional Rule 17 motions, significant additional Rule 17 motions. There's going to be additional Rule 14 motions. We're going to have to supplement the motion for disqualification that Mr. Yannetti just alluded to. We're going to need to supplement the motion to dismiss, which I'm alluding to. We will be filing a motion for extraordinary governmental misconduct based on certain evidence that we've just received.
This is the expression of a woman being vindicated after being put through hell by the Commonwealth of Massachusetts. She knew exactly what was provided by the U.S. Attorney and would be forgiven for believing it would lead to her freedom in short order. But this is the Honorable Judge Cannone's court, where justice bends and warps, skewed in the direction of Michael Morrissey's office, where the presumption is guilty and every tie goes to the Commonwealth. Nothing illustrates this mind-numbing distortion of truth better than what Laura McLaughlin says next.
The Commonwealth has had the opportunity to go through all the discovery that's been provided. It is voluminous. There's a lot of material there. However, the Commonwealth would dispute counsel's representation that the material is new information. I would say approximately 90% to 95% of the material that we've received is consistent with the Commonwealth's theory of the case and the testimony that went to the grand jury of witnesses' statements. There is some new information that counsel will use in their motion, and the Commonwealth understands that. However, I would say the evidence as a whole is very consistent with prior statements made by witnesses that testified for the Commonwealth.
Let that sink in as we consider the implications. Laura has the audacity to misrepresent the discovery materials. After reading all of Trooper Proctor's text messages, just handed over by the FBI.
You literally said that you hope that Karen Reed, the subject of your investigation, the woman sitting to my left, about 7 feet from me, that she would just die. Those are your words, right? All the powers that be want answers ASAP. Trooper Proctor, Karen Reed, in your investigation, had quickly become a very serious problem for you, hadn't she? Your life would be much easier if Karen Reed was just dead. This case involves a Boston cop whose family you're actually connected to. Julie Albert, Chris Albert, Colin Albert, Kevin Albert. She's a bitch.
Yes.
A whack job, correct?
Yes.
A retard, right?
Yes.
Her balloon knot leaks, right?
Yes.
No ass, correct?
Yes.
She's according to you, right?
Yes.
Ass leaking. That was ordered. It's a figure of speech, right?
Correct.
A girl who shits herself and then fuck her. And Trooper Proctor, it would be far easier for you to pin it on the girl who's just a whack job cunt, in your words, who you hope just kills herself, right? Now we have benefit of some hindsight, and that's the federal investigation. We have been saying since September 16th, 2022, in lengthy motions that we filed before this court and filed with the Commonwealth, there is a conflict. You're not investigating the conflict. That conflict was never described to the grand jurors. Newly uncovered text messages, but from the feds, revealed that on January 19th, 2022, think about that date, that's 10 days before the incident. January 19th, 2022, Michael Proctor texted his own family members discussing the specifics of having Julie Albert babysit for his toddler child. We should all let that sink in for a second.
So, yeah, I understand that.
Judge Cannone interjects, with what sounds like an involuntary reaction to Jackson's searing argument, but caught herself.
There is a level of closeness that cannot be overstated. Michael Proctor is so connected to the Alberts that he was entrusting them, or willing to entrust the Alberts, to be caregivers for his toddler child. For 2 years, the Commonwealth has been denying it and still denies it in their opposition paperwork. They still say, well, there's nothing to see here. It's Michael Proctor's sister who really is friends with Julie Albert, and that's not a big deal. Everybody looked the other way. Miss McLaughlin wrote the following in her opposition. Trooper Proctor's supposed close and personal relationship with the Alberts is, quote, entirely unfounded and a desperate creation of the defense, a desperate creation of ours. She says we created this. But now we have the benefit of the federal investigation. And the Commonwealth finds itself in that very unenviable position of having to eat some very distasteful words, because we didn't create anything.
Any other judge would be utterly shocked by what she's just heard, for the first time receiving full confirmation that the lead investigator has been hiding his relationship with the Alberts, and the Commonwealth has been lying about it in court. Instead, she's already formulating ways to excuse the misconduct. Cannone's behavior is particularly baffling given that she began her career as a public defender, fighting for clients being charged with serious crimes. Why isn't she angry that this has taken place in her courtroom and infuriated that a defendant's rights have been violated on her watch?
So now we have the lead investigator from Massachusetts State Police literally discussing the exchange of gifts between the Albert family on the one hand and the Proctor family on the other hand as a thank you, their words, for helping the Alberts out of a jam. And if you looked up quid pro quo in the dictionary, you would find this set of text messages. Any one of these examples, and I didn't touch on all of them, but any one of these examples, the gift giving, the babysitting, the telephone extraction, the Google search at 2:27 in the morning, all of these, any one of these would be enough to dismiss the charges as they sit here today. But the cumulative effect of this deception and all of it, this distortion in front of the grand jury, is too much for the court to ignore. The simple fact, Your Honor, is the presentation before by the Commonwealth before the grand jury in the state court action, it just wasn't fair. That's the easiest way to say it. It just didn't give Miss Reed a fair shot. It just didn't. That presentation was packed with lies, known lies by the investigators, and the omissions and the manipulations and deceit by the very people that are supposed to be the ones that we in the community can trust. The ones that are supposed to protect our interests, and the law does not allow this sort of conduct to go unchecked. When the remedy when this sort of travesty of justice occurs is established by this state's Supreme Judicial Court, and that is dismissal of the indictment in its entirety.
The district attorney's office is not accustomed to a criminal defendant fighting back in the way we have prior to trial. What usually happens when the prosecution brings charges is they detail the allegations at an arraignment in court, and as a result, their narrative and theory of the case becomes widely reported, while the defendant and the defense team remain relatively quiet. After arraignment, moreover, the media typically lose interest and wait until a trial or potential resolution of the case before they start reporting on the case again. And in this way, the district attorney's office is quite accustomed to always controlling the narrative in pending cases, at least until the defense makes an opening statement at trial. And as long as the prosecution gets to control the narrative in the press, they have no problem with what's being reported. But of course, this case has been different. Their control of the narrative did not last very long here. In our view, it became clear very early on in this case that their narrative was wrong. Their theory of the case was wrong. Their allegations did not fit with the evidence that we fought so hard and for so long to get access to over 2 long years. Never in over 30 years of practice have I ever witnessed an elected DA so blatantly violate the rules of professional responsibility. It pains me to have to file a motion like this. But DA Morrissey, through his poor and unethical decision-making, to release a video statement designed to prejudice potential jurors against my client, has forced my hand. So the question then becomes, why did he do this? Why did he take such a personal interest in this case such that he would take the unprecedented, and that's his word, unprecedented step of vouching for Commonwealth witnesses? Why would he take the unprecedented step of denigrating the defense theory to potential jurors? The unprecedented step of announcing to the public that Karen Reed is guilty? Why would he trample over the presumption of innocence and announce that we're trying to reassign the guilt that he's already assigned to her? Well, on December 4th of 2023, we began to learn why.
The first letter is dated May 9th. It's from the Norfolk DA's office to the U.S. Attorney's office in Boston. At the time, the DA's office knew that 2 people connected to the Karen Reed case had received subpoenas for a federal grand jury. The DA's office essentially wants to know what it's all about and reminds the U.S. Attorney's office it needs to share its findings if those findings impact the state prosecution of Reed.
The DA, in a desperate attempt to learn what the feds had uncovered, requested information under the guise of fulfilling his duty to disclose evidence to the defense. But as we learned later, he never even mentioned the existence of a federal investigation. This was after Turtle Boy broke the story. Morrissey knew that if the public learned he was under investigation, it would be like throwing gasoline onto a roaring fire.
The second letter, just about a week later, and we've reported on this one before. It's from DA Michael Morrissey to the Department of Justice's Office of Professional Responsibility in Washington. Morrissey requests that the federal investigation be moved out of Massachusetts, citing conflicts. He reveals that acting U.S. Attorney Josh Levy contacted the DA's office weeks earlier to say the feds were conducting an investigation that may involve a number of witnesses in the Karen Reed case. DA Morrissey tells the feds there is no evidence of corruption, and he accuses former U.S. Attorney Rachel Rollins of weaponizing the United States Attorney's Office to conduct an unprecedented intervention into an open state murder case. That takes us to June 12th. Acting U.S. Attorney Josh Levy tells the Norfolk DA's office that the feds have no issue with the DA's office telling Karen Reed's legal team about their communication. Levy says, "We will be back in touch with you as circumstances dictate." And in August, that office told the Norfolk DA it was essential to continue their investigation given what they knew, and they denied the request for a recusal, saying acting U.S. Attorney Josh Levy has a, quote, very different opinion of the circumstances in this case than as presented in Mr. Morrissey's letter.
That correspondence revealed that federal authorities were investigating this case, and it's worth noting they only released those to us once Fox 25 had succeeded in a public records request, and they knew what they had kept hidden was going to be revealed. And once we got those letters, we learned why they wanted them hidden. We learned that in May of 2023, the DA's office knew there was a federal investigation. They did not reveal that knowledge to the defense. In fact, on June 12th of 2023, the acting U.S. attorney specifically told the DA's office they could reveal the existence of this federal investigation to us, but they didn't. They kept it secret. And then worse, Your Honor, on December 4th of 2023, the district attorney's office provided a false notice of discovery to this court and to the defense. In that notice of discovery, they claimed they had received no confirmation that any witnesses had testified before a federal grand jury. We now know that was
a lie. Norfolk DA Michael Morrissey had known that they were under federal investigation since May of 2023, and then 7 months later, on December 4th, lied to the court in an official notice of discovery. This is crucial, as it serves as irrefutable evidence of their active attempts to hide the truth. They are willing to lie to this court, and the court, in turn, is willing to look the other way. It's hard to imagine that the DA would take such risks without assurances that nothing would happen when this violation inevitably came to light. Michael Morrissey's unprecedented statement becomes far clearer when considered alongside the FBI investigation. As David Yannetti alludes, it's evident that the DA was attempting to get ahead of the scandal before it reached the public eye.
a lie. We know it's a lie because 7 months earlier, DA Morrissey wrote that multiple state witnesses had received subpoenas. We know that was a lie because now that we've got the information from the feds, Nicole Albert testified before a federal grand jury that she participated in a group conference call with Jennifer McCabe, Matt McCabe, Brian Albert, ADA Lally, and victim witness advocate Stephen Nelson, a group conference call before she testified before the federal grand jury in July of 2023.
What would be the reason for Lally to prepare witnesses for a federal grand jury? It raises suspicion as well as concerns of undue influence in cross-jurisdictional conflicts. His only instruction should have been tell the truth, and that lying to the U.S. attorney is tantamount to hanging yourself.
We also know it was a lie because he wrote in his letter, and I quote, "We have confirmed that witnesses testified before the federal grand jury." Yet 7 months later, the DA's office tells this court that it had received no confirmation. That is outrageous. We are outraged that he lied to us. This court should be outraged that DA Morrissey lied to you. He also wrote that the head of the public corruption unit at the U.S. Attorney's Office may be personally retaliating against him and targeting him because his wife was unhappy with the way the Norfolk DA treated her. He wrote, in short, that he knew, felt, and believed that he and his office were being targeted.
The Karen Reed movement has in the past been accused of believing a conspiracy theory. It's hard to express exactly how satisfying it is to witness the district attorney himself, reduced to the ramblings of a tinfoil hat-wearing Illuminati conspiracist. Make no mistake, the DA's wild assertions that federal officials are out to get him are as unhinged as anything you can find on a 4chan message board.
Now, why is that important? It's important because of the immense power that a prosecutor has. It is important because we need an unbiased prosecutor with no vested interest in a case to try to administer justice based on the evidence and not based on any personal interest in a case. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. The prosecutor can order arrests, present cases to a grand jury in a secret session, and on the basis of his one-sided presentation of facts can cause the citizen to be indicted and held for trial. While the prosecutor at his best is one of the most beneficial forces in our society, when he acts with malice or other base motives, he's one of the worst. In his own words, DA Morrissey revealed he has an interest in this case that goes beyond the interests of justice. He revealed that he knew that his office was being unfairly targeted and investigated.
David Yannetti goes on to state the central thesis of this presentation.
He has a personal interest in getting Karen Reed convicted. If he can use whatever means he has at his disposal to convict her, and he succeeds, that would vindicate him and harm the federal investigation of his office. On the other hand, if she's found not guilty, as we expect she will be, he knows that he and his office will remain in the crosshairs of the federal investigation. DA Morrissey has an interest in this case not to do justice, but to win. That's why he hid his knowledge of the federal investigation for 7 months. That's why he slow-walked discovery. That's why he gave a lengthy video statement saying Karen Reed is guilty. That's why he talked about our theory being a desperate attempt to reassign guilt. And perhaps that's why, in contravention of Judge Krupp's preservation order, DA Morrissey's office gave the go-ahead to Brian Albert and Brian Higgins to destroy or dispose of their phones. We only learned that because the federal authorities revealed that in their investigation. And I'm just about ready to end. The DA also, as my colleague has indicated, the FBI has confirmed that Jennifer McCabe Googled how long to die in the cold at 2:27 in the morning. But what has not yet been mentioned is that 5 minutes before that, Brian Higgins and Brian Albert were calling each other at 2:22 in the morning on January 29th after previously testifying they were both asleep at that time. There was a lot of suspicious activity in the early morning hours of January involving the witnesses that Morrissey improperly announced to the public were telling the truth. We're getting to the bottom of it, and the truth will come out. But as we continue to defend her, Your Honor, like any criminal defendant, my client deserves a neutral, impartial prosecutor interested solely in justice, with no vested outcome in this case, and it's crystal clear we do not have that in Michael Morrissey. That is why he should be disqualified from this case, and that is why I urge you to do just that in the interests of impartial justice.
Even with the new evidence provided by the federal government, the motion for disqualification of the Norfolk County District Attorney was denied by Judge Beverly Cannone 2 weeks later, stating, contrary to the defendant's assertions, nothing before the court suggests that the DA has an interest in the outcome of the prosecution other than the interest of justice, never addressing the lies told by the Commonwealth. At this point, it was starting to feel like the strength of the defense's arguments simply didn't matter, as if guarantees were made, or at least implied, that Karen Reed would face a jury, regardless of circumstances.
The information that was disclosed to you folks from the U.S. Attorney's Office. So I read it. I see now how the federal investigation began and when it began.
Imagine such an experienced judge like Beverly Cannone, who has worked in the Massachusetts legal system for decades, reading the FBI documents and getting a clear understanding of the suspicious activity of the Commonwealth witnesses, then continuing to pretend this case has any legitimacy.
Every bit of discovery that the federal government has from the state case was provided by Mr. Yannetti. Nothing was asked for from the Commonwealth. Nothing was asked for from the district attorney's office, the state police, I have no idea what they have seen or what they haven't seen, how much of the file, how much of the discovery or anything else. And this goes back to November of 2022.
The federal government had no interest in communicating with Morrissey's office regarding this matter, which indicates that investigators discovered something damaging early on in their investigation, where they no longer trusted any Norfolk officials. They have godlike access to evidence that we will never see, and they know Karen did not commit this crime. Therefore, anyone suggesting she's guilty is doing so from an ill-informed position of pure and willful ignorance, if not self-preservation. Karen's guilt or innocence is no longer in question. What needs to be asked now is how far will a powerful man go to save himself, and how long before he's apprehended for his crimes. They were perfectly content when the Norfolk DA's office, the Massachusetts State Police, and the Albert family controlled the narrative, each vouching for the others, reinforcing their shared version of events. Then something miraculous happened. With only her close friends and family by her side, she had the bravery to stand up to the machine, climbing back from hell, out from the grave they had dug for her. And with the help of a fearless journalist, inspired the multitudes to stand with her.